She told her mother she would probably get arrested. Not in a moment of panic. Not in the fractured logic of someone who had just made a terrible decision and was scrambling to process it. Calmly, specifically. In a conversation that the FBI later documented as evidence, a statement made by a woman who knew exactly what she was doing, understood exactly what the consequences were, and kept doing it anyway. Courtney Williams was an employee of a classified Army Special Operations Unit at Fort Bragg, North Carolina. Her security clearance was TSSCI, Top Secret Hush-Hush Sensitive Compartmented Information, the highest tier of federal security clearance, granted to individuals who need access to the most sensitive national defense information the United States government holds. She had worked in the environment of special operations for years. She understood what classification meant. She understood what unauthorized disclosure meant. She understood better than most people will ever need to what the FBI does to people who leak national security information to the press. She told her mother she would probably get arrested. Then she made another call to the journalist she had been talking to for years. Over 10 hours of recorded phone conversations, more than 180 text messages. A relationship with a journalist that had produced across years of communication a systematic transfer of classified and controlled information about the tactics, techniques, and procedures of one of the most secretive special operations units in the United States military. On April 3, 2026, Courtney Williams pleaded guilty in federal court in the Eastern District of North Carolina. The charges: willful retention and transmission of national defense information under the Espionage Act. This is the story of what happens when someone with a TSSCI clearance decides that the rules governing classification don't fully apply to her, and of how the FBI builds a case against exactly that person using the records that the communication she believed was private inevitably leaves behind. Let's go back to Fort Bragg and build the case from its foundation. Fort Bragg, now officially renamed Fort Liberty but still widely referred to by its historical name, is the home of the United States Army Special Operations Command, the 82nd Airborne Division, the John F. Kennedy Special Warfare Center, and the unit at the center of this case, Delta Force, the 1st Special Forces Operational Detachment Delta. One of the most classified components of the American military, whose very existence was not officially acknowledged by the Army for years, and whose specific tactics and operational details are among the most carefully protected information in the American defense establishment. Williams worked in that environment. She was not an operator, not a member of the assault force that conducts the missions. She was an employee, working in the support and institutional structure that surrounds and enables Delta Force's operations. Her access to classified information was authorized and necessary for her role. Her TSSCI clearance reflected a judgment, verified through background investigation, ongoing monitoring, and the institutional trust that comes with sustained performance, that she could be trusted with information at the highest classification levels. That trust was wrong. The journalist who received the information has not been charged. Journalists, under the First Amendment framework that governs media law in the United States, are not typically prosecuted for receiving and publishing classified information that sources provide to them. The legal exposure falls on the source, the person with the clearance and the obligation, not the reporter who publishes what they receive. The journalist is not the story, Williams is. What's your read when a cleared employee with TSSCI access tells her own mother that she'll probably get arrested and continues anyway? What does that tell you about how the security clearance system's psychological assumptions about insider threat deterrence actually hold up in practice? Type A if the deterrence worked partially. She knew the risk and took it consciously. Type B if the deterrence failed completely. The knowledge of consequences had no moderating effect. Drop it in the comments. The information Williams transmitted covered the tactics, techniques, and procedures of Delta Force. TTPs, in military parlance, are the operational methodology of a unit. How they plan missions, how they conduct entries, how they communicate, how they adapt under fire, how they coordinate with other units, how they handle specific threat scenarios. For Delta Force, whose missions represent the most sensitive and high-stakes special operations, the American military conducts. The TTP documentation is among the most valuable intelligence targets an adversary could pursue. Williams was not transmitting this information to a foreign intelligence service. She was transmitting it to a journalist. The legal distinction matters. The Espionage Act applies regardless of the recipient's identity. What matters is that the information was classified, that Williams was authorized to access it but not to transmit it to unauthorized recipients, and that she transmitted it anyway. A journalist is an unauthorized recipient under the Espionage Act, just as a foreign intelligence officer would be. The 10-plus hours of recorded phone calls, the 180-plus text messages, the sustained, documented communication across years, all of it created a record that, once the FBI opened its investigation, was available for forensic recovery and analysis. How the FBI opened the investigation is not disclosed in available public filings. Leak investigations of this type typically begin through one of three mechanisms: a counterintelligence referral when classified information appears in published reporting, and the content's specificity allows for a source assessment; a referral from the classified unit itself when it identifies a likely unauthorized disclosure, or a tip from within the communication chain. The specific mechanism that initiated the Williams investigation is not part of the public record. What is public is the outcome. Over 10 hours of calls, 180-plus messages, a TSSCI clearance holder, and a statement to her own mother that she knew the consequences and had made her peace with them. Subscribe and hit the notification bell, because the specific charges Williams faced, the willful retention and transmission standard under the Espionage Act Section 793, and what willful means in the context of someone who predisclosed her own probable arrest, is one of the most specific examples of conscious espionage-adjacent conduct the Eastern District has prosecuted in recent years. Section 793 of the Espionage Act, the provision under which Williams was charged, covers the unauthorized retention and transmission of documents, writings, code books, signal books, sketches, photographs, and other materials relating to the national defense, with the intent to use them in a manner that could be used to the injury of the United States or the advantage of a foreign nation. The willfulness standard in Section 793 requires that the government prove the defendant knew her conduct was unlawful. Williams' statement to her mother, the specific acknowledgement that she would probably get arrested, is as close to a direct confession of willfulness as federal prosecutors typically encounter in these cases. It eliminates the defense most commonly raised in leak prosecutions, that the defendant did not understand the legal significance of her actions. She understood, she said so, to her own mother, and then she continued. The 10 hours of calls, the 180-plus messages, the sustained engagement with a journalist across years, during which Williams transmitted information that a federal judge found sufficient to support an Espionage Act charge. Delta Force's TTPs are now somewhere in a journalist's records. Some of them may have been published, some may have been reported. The specific content of what Williams transmitted, the specific operational details that moved from a TSSCI-cleared employee at Fort Bragg to an unauthorized recipient, is not described in the public charging document. You've seen the full picture. 10-plus hours of calls, 180-plus texts, a TSSCI clearance, a confession to her mother, an Espionage Act guilty plea. What would you have done differently as an Army counterintelligence official when the first indication of the leak appeared? Move immediately to preserve the communication records or take more time to build the full scope of the disclosure? Comment your call below. Williams pleaded guilty on April 3, 2026. The specific sentence had not been entered as of the most recent available public filing. Sentencing was scheduled for a later date. The Espionage Act provisions under which she was charged carry maximum penalties of 10 years per count. The actual sentence will be shaped by the federal guidelines, the extent and nature of the classified information she transmitted, her cooperation with investigators, and whatever mitigating factors the sentencing judge considers. The journalist she communicated with has not been publicly identified in the charging documents. The publication where the information may have appeared has not been identified. The specific content of the disclosures, the precise nature of the Delta Force TTPs that Williams transmitted, is not in the public record. What is public is the legal structure, a cleared employee, an unauthorized recipient, classified information transmitted, a willfulness statement made to a family member, and a guilty plea that converted the FBI's investigation into a federal conviction. These investigations, FBI Charlotte Field Office coordinating with Army Counterintelligence and the DOJ National Security Division, represent the specific category of insider leak prosecution that the national security establishment describes as its most difficult counterintelligence challenge. External penetration of classified systems is detectable through network monitoring. Authorized insiders transmitting information through their personal devices in voice calls and text messages is harder to detect and harder to prosecute than any other category of classified information loss. Williams was caught. Her statement to her mother is part of the federal record. If this level of detail is what you come here for, a thumbs up is the best way to support this work. Delta Force continues to operate. Its TTPs continue to evolve. The specific information Williams transmitted represents a moment in time. Information about how the unit operated during the period of her employment, information that may already be outdated by the operational adaptations that any competent special operations unit makes continuously. But the principle that a TS-SCI clearance grants the holder the responsibility to protect the most sensitive national defense information the government produces is not outdated. It is the foundational premise of the entire classification system. The premise that individuals who are trusted with that information will honor the trust. Williams honored it with 10 hours of calls and 180 plus texts, and then she told her mother she would probably get arrested. She was right. Was this justice? An Espionage Act guilty plea for a Delta Force employee who systematically transmitted classified special operations tactics to a journalist over years with full knowledge of the legal consequences? Or does the gap between the conduct, years of classified leaks, and the available penalty, a maximum that may not fully reflect the operational damage, say something about how the Espionage Act handles the media leak category? Drop your verdict in the comments. One detail, the one that the guilty plea does not answer. She told her mother she would probably get arrested. The conversation was documented. It became evidence. The specific words she used, the specific acknowledgement of what she expected the consequences to be, are in the federal record. What the record does not contain is what came before that conversation. At what point in the 10-plus hours of calls and 180-plus messages did Williams cross from believing she could avoid detection to believing she would probably be arrested? What changed in her assessment? What did she know about the investigation or suspect about her exposure that made the arrest seem probable rather than possible? The guilty plea forecloses those questions publicly. The sentencing memorandums may address them privately. The public record has the outcome. A TS-SCI clearance holder at Fort Bragg, Delta Force TTPs transmitted to an unauthorized recipient, years of communication, a statement to a parent, and a federal courthouse in North Carolina. She was right about the arrest. The sentence will tell us if she was right about anything else. What's the detail that stays with you? The 10-plus hours of calls that built the evidentiary record she couldn't escape? The statement to her mother, knowing the consequences and continuing? The classified unit, Delta Force, and what its TTP information actually represents? Or the gap between what the public record shows and what it deliberately doesn't reveal about the content of the disclosures? Let's discuss it below. And if there's a federal case you want us to investigate next, leave it below. The notification bell is the only way to make sure you're there when it drops. The broader pattern that Williams' case sits within is one the DOJ and the FBI have been tracking with increasing urgency across the past decade. Leak prosecutions under the Espionage Act have historically been rare. The statute was used only a handful of times before 2009, then more aggressively as the national security establishment identified unauthorized disclosures to the press as a priority enforcement area. Each prosecution produces a specific deterrent signal. Each plea or conviction says, the Espionage Act applies to media leaks the same way it applies to foreign intelligence transfers. The recipient's identity changes the political and media response to the prosecution. It does not change the legal framework. Williams's case will be cited in future prosecutions and in the security briefings that cleared employees receive when they are granted TS/SCI access. It will appear alongside Daniel Ellsberg, Reality Winner, and the other landmark cases that define what the Espionage Act actually reaches. It will appear with a specific feature that most of those cases don't have. The defendant acknowledged to her own mother that she expected to be arrested and then continued anyway. That acknowledgement is now in the federal record. It is the specific evidence of willfulness that makes this case a textbook example of the state of mind the Espionage Act requires prosecutors to prove. 10 hours of calls, 180 messages, one conversation with a parent, and a federal courthouse where it all resolved into a guilty plea on April 3, 2026. The sentence is coming, the record is permanent, and Delta Force is still operating, adapted as special operations units always adapt around the specific vulnerability that one employee created in the FBI's investigation contained.